Hello and welcome to Legal Basics with Cyril Law Global, and my name is Sian. Today we discuss a form of business organization that is a company. So what are the features of a company? First, a company has limited liability. Secondly, a company has perpetual succession. This means that even when the owners of a company die, the company itself remains intact. Thirdly, the company has corporate status. Corporate status means that a company is a separate legal entity from its owners. So that means that the company can enter into contracts, it can sue, it can be sued. Now, at the point of registration of a company, two documents are very critical. That is the memorandum and the articles of association. The memorandum deals with the relationship between the company and the outside. For instance, it will specify what services a company offers, it will specify what goods a company supplies, it will specify how a company can be taken over, whether it can borrow, whether it can sell or own property, generally how this company interacts with the world outside of it. Now, the articles of association, on the other hand, specify how the internal issues of the company will be handled. For instance, for companies that are owned by families, the articles of association can limit who can be a shareholder in that company. It can specify that certain biological children or siblings are the only people that qualify to be shareholders in that company, and in that case, the shares can never be transferred to strangers. Under the Articles of Association also, decision making is handled, how are decisions arrived at. In our previous broadcast under general partnership, we explained that under a partnership deed, how decisions are arrived at need to be specified. The same thing happens when you come to a company. Under the Articles of Association, the mode of decision making is explained. How big decisions or major decisions and minor decisions are to be made. Minor decisions may be made by directors, major decisions may be made by shareholders, but even at that level, it specifies which percentage, whether a decision needs a general consensus, whether a decision needs a simple majority, whether a decision needs certain amount of shareholding to support it for it to fly. Now, remember, because a company is a separate legal entity from its owners, it means that the liabilities of the liabilities of the company do not affect the owners. However, remember, limited liability does not mean that shareholders do not have liability. It simply means that their liability is limited. For example, let's say that a company has been formed with 100 shares and each share is worth 1,000 shillings. So the nominal share capital for that company is 100,000. Now, if let's say person X owns 10 shares, that means the value of his shares is 10,000. If this company gets into liability that overwhelms it, for example, it gets into debt, it gets into a loan and then it defaults and it cannot pay, or maybe there's a judgment against the company that it has to satisfy, and the assets of the company are not enough to satisfy it, then the owners of the company will be liable up to the level of their shareholding. So this means that if I own 100 shares and each share is worth 1,000 bob, then in case the company cannot satisfy its liabilities, I am liable up to the tune of 10,000 bob. That is exactly what limited liability means. It does not mean that you're not liable. It only means that you're liable up to the tune of your shareholding. I hope today's broadcast has been helpful. Please reach out to us with your queries. Please email us at cyrolowglobal@gmail.com. Sanitize, stay safe. Bye-bye.